Some of you mentioned the dumb Starbucks stunt, which was a real thing, but it wasn't the most interesting dispute over a coffee shop that used Starbucks trademarks to mock it. That was a New Hampshire coffee shop called Black Bear Micro Roastery, which decided to call one of its blends the Charbucks blends, or Mr. Charbucks, to mock the over-roasted taste of the Starbucks brew. And Starbucks wasn't happy about it, so they sued, and it went to a bench trial. That means a judge led the trial. The big issue was dilution. Dilution is different than trademark infringement. Trademark infringement is based on consumer confusion. Dilution is based on harm to the distinctiveness of a famous brand, which Starbucks is. But Starbucks lost. Charbucks won, and Starbucks appealed, and Charbucks won again. Charbucks did a victory dance. But it wasn't over, and for me to explain why, I got to tell a completely different story about a lingerie and sex toy shop in Kentucky owned by a couple named Victor and Kathleen Mosley, who decided to name it after him. So they named the shop Victor's Secret. You can see what the problem is. They did some advertising. An Army colonel saw the advertisement and got really angry, and his anger was the spark. It was the butterfly effect that changed trademark law, the Benoit ball effect, if you will. He wrote to Victoria's Secret saying that he was angry that this store was using the good Victoria's Secret name to peddle its cheap and tawdry merchandise. Victoria's Secret sued, and that dispute went all the way up to the Supreme Court, which held that for a dilution claim, it's not enough to show a likelihood of dilution. You have to show actual harm. You have to show that the dilution already happened. Well, that's too late. The harm is already done, Victoria's Secret said, but the Supreme Court said that's not our problem. We don't write statutes. So that motivated big brand America to get to Congress and have a big overhaul of trademark dilution law. That was the Trademark Dilution Revision Act of 2006, which provided, among other things, that to get an injunction to sue for trademark dilution, you need only show a likelihood of dilution, a likelihood that your famous trademark will be harmed. That revived the Victoria's Secret lawsuit, which they did win, and the store became Kathy's Little Secret. It also revived the coffee shop lawsuit, and Starbucks lost again, appealed and lost again, and the brewery got to keep its Charbucks name, I guess.